I think the record...
All right, Mr. Fong, why don't you wait outside for us? Thank you. Mr. Schick.
Thank you, Your Honor. And even if one gives every reasonable assumption to the prosecution in terms of this course of conduct, I don't think that there's any question, but what happened here was a deliberate and intentional misconduct on the part of the prosecution. In making this argument and in drafting a proposed instruction to the jury, I intend to follow very carefully this court's decision with respect to the videotapes in the Rosa Lopez matter. In this court's decision, with respect to failure to disclose certain matters of discovery, the first factor that the court began to look at was the history of discovery proceedings up to this point. First, other factors, other problems that have arisen. And I would note for the court that there have been quite a few problems with respect to the discovery on evidence collection. First, there's the matter that the court still has under submission of the failure to disclose the videotape of Mr. Simpson's residence, which has some very material information in it, in particular the time in which the tape was taken and the very suspicious absence of the socks as the camera pans Mr. Simpson's bedroom and what the prosecution is saying about 414. More disturbing still is that the prosecution indicated that they had turned over to us the serology room transaction cards, which would indicate who went in and out of evidence processing room transaction card sheet, indicating who would go in and out of the evidence processing room on the morning of June 14th.
That's false, Your Honor.
Wait. Mr. Goldberg, you know how this works.
Apologies.
All right. Proceed.
Mr. Goldberg turned over these printouts of the evidence processing room, and to give him every benefit of the doubt, what he has told us is that he turned over what he had, which did not include the times of the early morning. It only started, I think, around 9:40, but it didn't include the early morning. And he indicates that in terms of what he had, he didn't have it either. All right? And he didn't give us a complete set. That's what he says. Let's just take it as he says it. Nonetheless, we didn't get it. We eventually got it during cross-examination, in the middle of the cross-examination of Mr. Fung, but that happened. Then there are other disturbing problems with respect to our access to this evidence, and that is that with respect, for example, to the hairs and fibers from the hat found at Rockingham, a bindle was created by Dr. Lee of hairs and fibers that was removed in Albany.
But isn't that a factual issue that I haven't resolved yet?
Oh, no, I understand that. I'm just saying the state of the record. I'm trying to be as objective as possible in setting the background for what I think is the real egregious problem here.
No, but you're citing something to me that there's no factual determination that did or did not happen. We are aware of the LAPD video that was turned over in a light manner. I'm aware of the barcode, or I mean, not the access card records.
Right.
All right. But this other stuff I'm not familiar with.
Well, no.
I've heard it. It's not in the record.
Well, I don't. Well, I think it is in the record in terms of, and I don't think there'll be any dispute that what's happened here is that and Mr. Yokelson is still searching for it. I mean, and we've been talking about it, and they're searching for it. But the fact of the matter is that these hairs and fibers were taken off the hat. A bindle was created. It was photographed back at the crime lab, and they haven't found it yet. There is, again, the matter of the lens and the prescription glasses, which, again, is at this point unaccounted for. The reason I raise this, Your Honor, is that the difficulty that I have here, and I think it fits into one of the factors that the court considered on the discovery sanction, and if I may quote you, is that what you're looking for in terms of these discovery sections is that we have to assume that on important issues that an absolute bare minimum of professional competence would require that the lawyer preparing to present testimony of witnesses confirm an inventory of statements, reports, notes, recordings, etc. Now, all that I'm saying here, Your Honor, is that I think that there's a clear pattern that in this discovery that what's been going on is that the prosecution is far more concerned with what they think the defense is going to find than they are in ensuring that they are really turning over to us all the evidence in an accurate and complete form. And that the fact of the matter is that I'll proffer to the court. What's been going on, as the court's well aware, is that we go to the laboratory and we have visits and we try to examine documents and evidence, and everybody sits there and they take notes about exactly what we're looking at and exactly what we're thinking.
Well, Mr. Scheck, what I'm really interested in, though, are the facts and circumstances that surround page 4.
I understand. I think that's a necessary backdrop because it's a factor that the court's considered. As with respect to page 4, I think that this is a clear statement of the record. We went and visited the LAPD laboratory and asked to examine the original notes of the crime scene checklists at Rockingham and Bundy and everything that was filled out by Ms. Mazzola and Ms. Fung. That was delivered to us at the SID laboratory in the presence of Mr. Goldberg by Greg Matheson, and they gave us a book that purported to be originals. There are 2 laboratory notes that were taken by, I believe, Mr. Matheson at this time that actually document this and document how Mr. Neufeld was looking at the original notes of Fung and Mazzola, and we went and asked if we could copy them, and how I was looking at the field notes while Mr. Neufeld was checking his notes. There are records of them watching us looking at these documents with great care. I'm sure Mr. Goldberg will not dispute that at that evidence lab, when I looked at those original documents, obviously I was very concerned because I thought that I asked Dr. Lee to come over and look at it. I thought that I found a discrepancy in terms of the originals. I asked Mr. Goldberg if we could copy it.
Excuse me a second. Mrs. Robertson, can I have both page 4s, please?
I asked Mr.
All right. I'd like to see them, please. All right. Go ahead.
I asked Mr. Goldberg if we could make a copy of the originals. He was reluctant to do so. He didn't want to make a copy of the originals right there in the lab. I then appealed to Mr. Yokelson, and Mr. Yokelson agreed, and a copy of those originals was then turned over to the defense. Subsequently, as the court is well aware, we made a specific request, a written request, to have all the original documents from the checklists examined by a document examiner. The district attorney's office balked and asked that I make an offer of proof, or they contested our right to have a document examiner look at the original documents. What they were telling us were the original documents. As the court, I'm sure, recalls, I made an ex parte offer to the court, and in that ex parte offer, I explained to the court very clearly what I thought the problems were, that I had seen this erasure with respect to somebody going back over the documents on July 4th, that we didn't see any staple holes.
July 5th.
I'm sorry?
July 5th.
July 5th. That we did not see any staple holes on page 4 of the Rockingham checklist, and believed that that was not an original, and I wanted to have an expert examine that and the other documents. I explained to the court at that time that it was our contention in this case that we did not believe that Mr. Fung had ever received Mr. Simpson's blood vial on the afternoon of June 13th, but in fact had received it in the morning. I further pointed out to the court the written documentation on where Ms. Mazzola had indicated that the blood vial had been received after the sneakers. I further pointed out to the court her testimony at the split hearing, which Your Honor heard, in which she indicated that she did not recall, essentially, seeing Mr. Fung receive this blood sample from Detective Van Adder on June 13th. So the document examination occurred, and we were operating on the assumption, because it was a representation by the prosecutors, that the documents we were looking at were originals. I don't think there's any question. The prosecution concedes now that that was a false representation. We were not looking at originals, that in fact page 4 they are claiming was not the original. And it was perfectly plain, I think, after document examination that that page 4 was not the original. And we relied upon that representation. During the course of Mr. Fung's testimony, he made representations, and it was our understanding from looking at the manual, that all original documents are supposed to be kept in one place within the laboratory, and that they're collected there for purposes of review by supervisors, and he agreed that that was true and that the documents that had been segregated were the originals. Then there was another document, and I'd like to get the exact, it was first introduced by the prosecution, and that was a document that had an L number on it, and it referred to, it was undated. It was written on a field report note. L16, and there's a specific prosecution number, I can't recall what the number was, but it was used with Mr. Fung on direct examination. Mr. Yokelson, Mr. Hodgman, and Mr. Goldberg represented to us that they had not yet found the original of that lab sheet. So on direct examination, an original was not used, an original had not yet been located. The day before, I guess it was the day before yesterday, maybe Mr. Goldberg knows it better than I do, but I think it was the day before yesterday, which would make it Wednesday. Mr. Goldberg turned over the original. They had found the original. Presumably, I take it from what they're saying, that they found the original in Mr. Fung's own notebook. That, I would submit, Your Honor, should have put them on notice that perhaps they had not turned over all the originals to us as they had represented they had done, and it was a representation, obviously, that we were relying upon, and relying upon heavily in terms of framing a final line of cross-examination. So I would say at this point, in terms of the court's discovery analysis, that certainly we have a false representation, and the question is whether it was inadvertent neglect or gross neglect. I would submit at this point we can at least assume it's gross neglect, and let us assume that it was not knowledgeable or intentional up to this point. In other words, when I was cross-examining Mr. Fung yesterday, even after they realized that there might be some originals in his notebook and some of the documents they gave us were not originals, let us assume that they did not know and they were not intentionally trying to set us up in terms of the cross-examination. All right? It's just a gross neglect at this point. However, what happened afterwards clearly is intentional misconduct. This was an important witness, and the issue here was a critical one. Whether or not this blood vial was turned over, we all know that we're about to broach the issue in opening that about a quarter of Mr. Simpson's blood sample is unaccounted for based on the records that we had been given up through the opening statement, and we opened on it, and we think that that is an extraordinarily serious issue in terms of tampering with evidence. It goes to the heart of this case. Mr. Fung had been impeached on many points that I think it's fair to say have damaged his credibility in terms of other important pieces of evidence. The Bundy glove, the movement of those which he can't account for, an envelope where he was taking it with his bare hand where that was caught on videotape. But then, of course, the most important fact of all is that during the examination yesterday, and I must say that the court extended every possible courtesy to the prosecution in terms of allowing them to look at these videotapes. You handled it very, very carefully, trying to prevent
Not carefully enough.
Well, trying to prevent any unfair surprise. I mean, they were given all the videotapes. The only thing that I was reluctant to reveal to them openly or in an offer of proof to you is that by looking at the cars, we had ascertained that Mr. Fung's testimony that he had carried a blood vial out in the brown bags, the posse box, or in his own hands was false. But in terms of giving them the real evidence, they had it. They had an hour to look at it. They had a long time to think about it. The court conducted the examination outside the presence of the jury. It was done by the book. What happened here, however, Your Honor, is that at some point in time, before I finished my cross-examination, before I stood up after the break and said no further questions, the prosecution, if we take them at their word, went through Mr. Fung's book and discovered the original page 4. Given their representations that they had given us all the originals, the proper course of conduct at that point would have been to inform the court and counsel that their prior representations had been false. They purposely did not do that. Instead, what they tried to do was begin a direct examination to rehabilitate Mr. Fung in an unfair way, to try to rehabilitate his credibility on this critical issue of whether or not he got the blood vial on June 13th as opposed to the morning of June 14th. And they then began to do that on redirect examination. I heard the first question about the one sheet that they had originally told us was not an original and they'd found the original. That was fair enough. Then, to my great surprise, I heard that second question, and that is about page 4. Now, the real danger, this is intentional misconduct. They knew it. They had a break to think about it. They all sat here and discussed it. Mr. Harmon, Mr. Clark, Mr. Goldberg, and Ms. Clark. They sat there and they discussed it and they thought about it. And they thought, wouldn't this be terrific? Let's rehabilitate Mr. Fung. It'll look like this was an innocent mistake, and therefore all the other contradictions caught on videotape, contradiction is his own testimony about this blood vial, they'll then be able to argue it was just an innocent mistake and he's telling the truth. And that's how they began their rehabilitation of this witness, trying to exploit their own misconduct and their own misrepresentations. There is no question, giving them every benefit of the doubt, that that was deliberate, it was intentional, and it was wrong. Now, this, I would submit to the court, is far worse than anything that occurred with respect to withholding tapes on Rosa Lopez. Because, at least in that situation, first of all, I don't think that the court made a finding of intentional misconduct, or there was a basis of the record that it was as intentional as this, because this is clearly deliberate. Not to turn it over before I had finished my cross-examination and then to try to use it to rehabilitate this witness's credibility. And it has a terrible effect because of the way that cross-examination ended and the jurors were looking at the documents. What they're trying to achieve here is the jury should forget all those other serious contradictions because of this point about page 4. Now, I'm assuming for the sake of argument that their claim is correct and this is in fact the original. Just assuming that. So this is true misconduct. It is intentional. It is worse than the Rosa Lopez situation because at least in that instance, before cross-examining Rosa Lopez, the prosecution got an opportunity to listen to those tapes, to go out and interview witnesses, and the court extended them absolutely every opportunity so that they could not be damaged by this. In truth, there's no way to unring this bell. It's quite startling to me, Your Honor. At sidebar, when I raised this issue yesterday afternoon, Mr. Goldberg actually said, well, Mr. Scheck was trying to achieve a Perry Mason moment here. He was hoisting on his own petard, and he didn't say that, but words to that effect. And then he said, what Mr. Scheck should have done here is come to me and said, hey, what about that page 4 that, it's obviously not an original, and I should have tried to straighten all that out with him. And then he cited the fact that they had told us that that other page from the lab book wasn't an original, and then at the last moment turned over the original from Mr. Fung's notebook. Now, that's fairly incredible. That shows that they seem to have no idea of the rules. because the fact of the matter is that they're the ones that were representing to us all the way along the line that we had a set of originals, and they were not taking proper care to make sure those representations were accurate all the way through the point of cross-examination, and then it got fatally worse. After they knew that we had been misled and sandbagged by their false representations, they then intentionally, willfully went out to try to rehabilitate Mr. Fung's credibility, which they are desperate to rehabilitate at this point on a critical issue, by intentionally trying to exploit their own false representations. And they knew it, and they did it. So, Your Honor, that's why I've drafted a discovery sanction.
Instruction.
I'm sorry?
A discovery sanction instruction.
Discovery sanction instruction that mirrors, I think, in a totally factual way, almost word for word, the instruction that you crafted with respect to the Rosa Lopez issue. And I think that this situation is far worse, and that I frankly think that the only remedy that really would undo the damage here is preclusion. That, in truth, is the only remedy. However, I recognize that the court may very well be reluctant to grant that remedy, and so I've proposed this alternative instruction because it seems to me that you must instruct this jury in no uncertain terms about the misconduct of these prosecutors here, about what they did, because it is, and about their efforts to rehabilitate Mr. Fung's credibility improperly, intentionally, that this was a violation of the law, and that my instruction mirrors precisely what you have previously issued.
Thank you, counsel. Mr. Goldberg?
Thank you, Your Honor. Good morning.
Good morning.
I am outraged by counsel's representations and misrepresentations to this court, and I've tried to take three deep breaths in advance, Your Honor, but I truly am outraged. And I'm sorry, but I'd like to discuss some things that probably are not directly pertinent to the issues before this court, because Mr. Scheck addressed them, and I think that they can't go unanswered. First of all, I'd like to set straight what happened on this question of the door entry issue, which is an entirely irrelevant point. They never requested those documents ever at any time. I never had any conversation with Mr. Scheck about them or any other member of the defense team at any time. What happened on that issue is I asked those documents of Greg Matheson for the purposes of being able to try to reconstruct events that happened on the 14th, the 15th, the 16th, and the evening of the 13th. I wanted them. And once I got them, I Xeroxed them and turned them over without request. Counsel never had any conversation with me about them thereafter. Now, what happened on that issue is Mr. Neufeld called Greg Matheson. He did not go through me because they have a relationship with Mr. Matheson where they go to him directly, not even through the prosecution. And Mr. Neufeld apparently told Mr. Matheson that one of the pages was missing, and Mr. Matheson then caused that to be provided to them. But there was never any request, there was never any order for that item. Now, as to the next issue that he raised, which is the bindle, we believe, based on my conversations with Alan, that that bindle is perhaps in the court's custody. That has not yet been resolved. But I'd also like to point out that the prosecution cannot be blamed for any potential argument or any suggestion that perhaps the bindle that Mr. Lee created was lost, because when item number 6 came back, the control on 6 from Albany, it came back with a hair in it that was not there when it left. So we know some things happened to our evidence to change or alter the condition of that evidence in Albany by the defense experts, and we have photographic documentation of that. The next issue I'd like to raise in terms of misstatements by counsel is we discovered the existence of the real page 4 after cross-examination had been concluded, after counsel had represented several times to Your Honor, I can't remember whether it was on or off the record, that he was finished, that he had no further questions, and after I had requested a break and was given a break for the purposes of assembling my notes for for redirect examination. That is the point in time, and the first point in time that we discovered it. And the way that I discovered it is because I knew that two other documents, one other document, perhaps two other documents, were found in a similar manner, that they were found in Mr. Fung's notebook, and that he had the original, and that a copy was in the notebook that was supposed to contain the originals. I'd like to also address this issue of the Xeroxing of the crime scene identification checklist, which I believe happened in early May.
Well, Mr. Govey, let me...
In early March,
Before you move on to that, let me ask you a question about this discovery of the real page 4. At that time, do you believe you had an obligation, having now discovered that, knowing that the defense had made a request for a document examiner to examine each one of the pages of the crime scene checklist, and anytime you have the document examiner examine something like that, I mean, the implications are obvious. Don't you believe that you had an obligation upon making that discovery to immediately advise the court and counsel?
I did not believe so, Your Honor, and I'd like to address that in more detail, if I may, and very extensively. But with the court's permission, could I continue with the events that happened surrounding the Xeroxing of the crime scene identification checklist?
So long as you understand that that's my primary concern.
Okay. As to the Xeroxing of the crime scene identification checklist, which actually Mr. Scheck and I did together, I'd just like to set the record straight on that. They told us that told me, Mr. Scheck told me, that his only reason for wanting to look at these originals, and I guess this must have been some kind of a subterfuge because they didn't want to let me know what their real intentions were. He told me that they had written on their copies and that they didn't have any copies that were free of notations, and that they were kind of embarrassed about this, but were asking me to extend them the courtesy of Xeroxing those items, which I did not want to do because, as I have represented to the court, my Xeroxing skills are not the best. And it took us approximately 40 minutes to go through those documents, Mr. Scheck and I, and Xerox them, which I did as a matter of professional courtesy. What happened after that, after we were finished Xeroxing virtually all of the documents, is Mr. Scheck, who should win the prize of having Xeroxing skills that are even worse than my own, dumped out the entire volume of that original notes binder. And it was standing in a teepee fashion on the floor after we had gone through it. And it took us about 5 minutes to figure out how to undo that problem without getting the notes all out of order. And at that point, Mr. Scheck, well, about an hour or so later, asked me then to Xerox more documents pertaining to searches of vehicles. And naturally, I wasn't very eager to Xerox more documents at that time, and I said, I don't want to do it at that time. We resolved that issue, and then finally I decided that I would provide them with Xeroxes. But I'd just like the record to be straight as to the chronology of events and as to what happened during that incident. Now, Your Honor, I'd like to address this issue of page number 4, and the original versus the copy. First of all, I'd like to discuss it legally, which is something that Mr. Scheck didn't do. He made a lot of allegations, but he doesn't discuss the law. And I'd ask the court to go back to the law because ultimately this is a legal decision. 1054 of the Penal Code doesn't say anything about us providing an original document. It's not in there. The Constitution of the United States requires us to provide exculpatory evidence. What is page number 4? It is in front of Your Honor, I believe. It is a Xerox copy of a form. It doesn't have any writing on it. It doesn't have anything which would put any prosecutor or defense attorney, in my opinion, on notice that it is in any way relevant to this case, let alone exculpatory. So where is the legal obligation in any statute, in any case, in the Penal Code, under the United States Constitution, for us to have disclosed that document to begin with. It was disclosed, and we allowed them to Xerox and inspect them as a matter of professional courtesy. What happened, Your Honor, is that when they inspected these documents, they came to the conclusion, and I never looked at all of them and lined up the holes on the paper clips or the little holes at the top of the documents, and I never examined them with that degree of care.
Have you examined the little, since you're such an expert at Xeroxing, have you examined all the little holes that represent staple holes that appear on Xerox copies?
I see that there are staple holes on the Xerox copies, Your Honor. I noticed that this morning. And I did not go through them with a degree of care to realize that the staple holes on the Xerox copies are Xeroxed and not actual holes. And I wouldn't have even thought of doing that. And as an advocate, quite frankly, I would not have thought of predicating a conspiracy theory based upon the existence or non-existence of staple holes on page 4. So no, I did not look at it. And I don't believe that Mr. Hodgman looked at it. And I don't believe that Mr. Alan Yokelson looked at it with that degree of care. And we would not have. And I do not believe that we could have reasonably been asked to. Now, what happened is that after these documents were provided, counsel notified us that 2 documents were not original. One was L16. May I just refer to my binder, Your Honor?
Certainly. Mrs. Robertson? Excuse me just a second.
Sorry, Your Honor. One was L16, which is the item that discusses on 6/14/94 certain items being released to criminalist Yamauchi. And the other item that they said was not an original was L31, which is the document that lists item numbers 20 through 35, most of them being stains that came out of the Bronco. They said it was not an original. And I believe that we ultimately found originals on both of those items and provided them to the defense. They had a question document examiner look at them. They never notified us at any time or suggested to us that page number 4 was not an original. Upon closer inspection of that document, Your Honor, and especially with the aid of a question document examiner, it is obvious now to me that it does not have holes all the way through it. And they knew that. And with the relationship that Mr. Neufeld has with Mr. Matheson, he could have done what he has done on at least 2 or 3 other occasions and gotten on the phone with him or any of us and said, this is not an original, and the search would have been on as it was on the other 2 cases. He did not do that. Mr. Scheck did not do that. And I'm not faulting for them. I'm not telling you that they have any duty to do that. But they didn't. And they didn't do it for tactical reasons, and they are entitled to make that decision. And I don't know for sure whether I used the term hoisted on their own petard last night, but I'll use it now because that's what happened. They decided that they were going to predicate a theory that Mr. Fung was involved in a conspiracy on the existence or non-existence of staple holes. And they didn't want to tell us about it. And they didn't tell us about it. And we never made any representation specifically that we knew that that document was an original or that we had inspected that document. And we never would have even thought of doing so. And then after doing it, we did what any prosecutors would do in that circumstance and think, where can the original be? And they know we would have done that as well. And it was in the same place that the other document was, where we provided the defense with a copy instead of the original. And that is how we found it. Now, Mr. Scheck cited yesterday to the court what I called the I want to show it rule of evidence. When he was talking about wanting to show videotapes, he'd just say, I want to show it. And I said, I didn't see that in the evidence code. But I'd like to cite a lesser-known provision of the penal code called the It's Just Too Bad rule. They made a tactical choice. If they were interested in the truth, if they were concerned about not proceeding on a theory that could be easily disproved, they knew how to do that. And in prior occasions, they had used those vehicles and those avenues to try to clarify when they knew they had a copy instead of an original. They could have done it this time, but they didn't. And the prosecution cannot be asked to pay the price for that tactical choice. It's a legitimate choice. I understand that they made it, but we cannot be asked to pay and should be not be asked to pay. Now, I hate to get to the issue of sanctions, Your Honor, because we're saying there is no discovery violation, and we are saying that we did everything that a reasonably diligent prosecutor would do and more in accommodating and over-accommodating the defense. But you will recall that when the issue of sanctions came up yesterday, as to the defense tapes that were not displayed, I said, I can't ask for preclusion, I can't ask for an instruction, I can't ask for anything except some time to review the tapes. Even though it was clear that counsel was grandstanding in the way that they had disclosed these tapes. Because the sanction, if any, must fit the harm that has been done, if any. And the only harm that has been done here is that their tactical decision didn't work. And the remedy is nothing. It is to do nothing. And that's assuming there was a discovery violation, which we certainly don't concede.
All right, well, why don't we go back then to my question to you?
And your question was, did we have a duty to bring it to the court's and counsel's attention as soon as we found it?
Correct.
And we believed that we did not. We discussed it, and we felt that it was clear that they had made a tactical choice. It's clear that they could have brought it to our attention. It's clear that we were entitled to introduce this. It's clear that we had no obligation of the law, under the law to produce it. And at that time, at that hour, we believed we did not have an obligation.
Well, let me ask you this. Since I did make the order that the originals be produced for document examination, doesn't that include page 4 as soon as it's discovered?
And it was produced. I mean, it was produced in court.
Well, it was produced for I ordered it produced for the purpose of document examination by the defense, though. So didn't that place an obligation upon the prosecution to then produce that item?
I didn't hear the end of the court's question.
Didn't that place upon you at any point when you discovered that you had an original in your possession to notify the court, at least under 1054.7?
1054.7 is in-camera hearings.
That's correct. In other words, if you felt you discovered something that there was some question as to whether or not it should be turned over, then you have the right to ask the court to make that determination ex parte.
But, Your Honor, we never, that is true. We can have request an ex parte hearing whenever we feel we have information that we don't want to turn over. But we did want to turn this over. I mean, there's no question about that as soon as we found it, we wanted to turn it over. And we'd love the defense to have the opportunity to inspect it as much as they'd like to inspect it, and they will have the opportunity to do so. So we would not have requested an in-camera hearing under 1054.7 to say to Your Honor, we want to hold this back, because that was not our intent. And what I would ask the court is to think about also the court's order that the defense show us videotapes in advance, which has been repeatedly breached. And, you know, what sanction has been imposed? The sanction that's been imposed is the court has given us time, and we've been thankful for it, to look at those videotapes, because a lot of the times that's the only appropriate sanction that we can ask for. And that is all we have asked for. May I just have one moment? So what we would ask in the court to do is if the court's going to impose any sanction, that the court be even-handed, and that the sanction that would be imposed, and we're not saying that any is warranted because we're not seeing that there's any discovery violation, is to give the defense more time to look at it as the court gave us more time to look at the videotapes. The court must be even-handed, and we request Your Honor to do so, and I know you want to do so, in the way that the court makes its rulings. And I think that, if anything, this is comparable, but in our case, far less clear, because there was nothing that reasonably would have put us on notice. And I really feel a little bit reluctant to make this last argument, but in light of Mr. Scheck's argument, I don't think I have any other choice. And that is that when these items were being viewed by counsel, he said, well, we have notes of watching them view it and so on, as if there was something improper. Actually, what happened is I was in the room, it was actually the kitchen area and the library area of the Scientific Investigations Division on a Saturday. See, we opened up the laboratory for them on a Saturday so that they could be there. It's something that we do for every defendant who's on trial. And I was present when Mr. Scheck was viewing the notes, and I was present because I wanted to make sure that nothing happened to alter or change the condition of our original notes. And that was one of the conditions that we felt that we wanted to put on them looking at them. I was sitting at the extreme other end of a table that was approximately the same size as both tables that are in Your Honor's courtroom, in what I describe as a library/kitchen area of the lab, because I did not want to look over their shoulders, and I felt that my mere presence would be a sufficient deterrent. But I don't know everything that happened, and I wasn't watching them every moment when they looked at those notes. I don't think that would have been appropriate for me to have done. But if Mr. Scheck's Xeroxing skills are any indication of his ability to perhaps confuse documents, we don't know for sure what happened.
All right. Mr. Goldberg, I don't mean to cut you off, but I'm really not interested in those activities.
Okay.
All right.
And I'd also like to point out, and as I said, I apologize, and I apologize to counsel, but we have to sort out what happened here and how it happened. And there are a lot of facts that we just don't know. And that's all I'm pointing out, Your Honor. And I apologize to Mr. Scheck. I apologize to you for bringing these facts out at all. And I'd like to also point out that Mr. Scheck did have the notebook throughout the court session. So trying to reconstruct how this item number 4 happened isn't something that we could do with any degree of precision and certainty. And again, Your Honor, I don't like this kind of advocacy, and I'm not trying to cast any aspersions. All we're trying to say is that we can't reconstruct how those events occurred.
Thank you. Any brief response, Mr. Scheck?
Yes, Your Honor.
And would you focus your comment on the obligation to disclose upon discovery? That's the only thing I'm really interested in.
I understand. Your Honor, they just admitted it, didn't they? They said that they discussed it. They all sat there and discussed it and decided that they had no obligation. That's fairly extraordinary. Your Honor, Mr. Goldberg seems to think that when you issue a court order to produce the original documents for us to look at with the document examiner, that he was just doing us a professional courtesy. That's a court order to produce the originals. Representations were made that these were the originals. Then they got notice that there were some problems, and perhaps some of the originals might have been in Mr. Fung's notebook and not produced to us. Now, let's be very clear about those facts. Mr. Hodgman and Mr. Yokelson said, here are 2 documents that we know are not originals. The others that you're looking at are originals. These aren't, and we're still looking for them. And then they find them, apparently, in Mr. Fung's notebook, and that is more than enough notice that maybe this is going on, and maybe all the pages that they didn't give us in the first place were originals, and that we're in a perilous situation where we may be relying on something that was not originals. And obviously they had an obligation to make sure that they were giving us what they claimed to be originals in the first instance, and anybody could have seen from looking at those, if they'd examined them carefully, that there was certainly an absence of staple holes. And incidentally, Your Honor, in terms of the Xerox, there's also trash marks from the Xerox machines all over those pages. So I'm not sure it's entirely clear those are staple holes versus trash marks. But the point is,
Well, if you look at it, they seem to line up in the same
well, no,
places.
but those were also the Xerox trash marks, and they don't necessarily accord with all the staple holes. But that's besides the point, isn't it? The point
Allows you
is,
for the fact finder to determine on it.
well, no, Your Honor, let's say that is the original. Let's say that is the original. The point here is that Mr. Fung has been severely impeached on exactly how the...
No, Mr. Scheck, the point is, did the prosecution have an obligation upon discovering that they had it in their possession to notify you and the court that they had it?
Yes.
That's the only thing I'm really
Well,
interested
Your Honor, there's no question that under 1054.1, they must disclose all relevant real evidence obtained as part of the investigation. We asked for the originals. The court ordered them to turn over the originals. We examined the originals. Then they were on notice that they may not have given us all the originals. They took no steps. And then when they realized that they had misrepresented to us the fact that they had turned over all the originals and we'd relied on it, and I had not yet stood up and said no further questions because I didn't do that until after the break, they sat there, they discussed it.
After I reminded you to do that.
That's right. But it's clear. It's clear. And they sat there, they discussed it, and they actually decided intentionally that they could go about rehabilitating the witness because it would be helpful in order to make the jury think that all the other contradictions were just innocent mistakes, that they were going to do it even though they had represented to this court and to counsel all the way along the line that these were originals that we had. They didn't bring it out so that perhaps I could try to undo this damage myself in some fashion with appropriate stipulations that I had been misled, because that's exactly what happened, and they did it intentionally. And Your Honor, I know you don't want to hear these things, but I'm trying to be as careful and as factual with the record as I can, because there's an implication in Mr. Goldberg's remark. I will readily admit to being a klutz. And when I said yes, no, you have to hear this.
No, I don't have to hear it.
Well, no, Your Honor,
Mr. Scheck.
he's just wrong in his factual statements.
No, Mr.
There-
Scheck,
the notes
no,
show-
Wait,
I didn't Xerox those field notes.
Mr. Scheck,
Okay.
I'm sure it's interesting to hear, but it's
Yeah.
not really relevant to the decision I have to make.
Fine. It's just, all right. What he said wasn't accurate, and I can prove it. The point is this, that everything that I've said in terms of giving them a reasonable benefit of the doubt, every factual innocence, every factual assumption,
Well, counsel,
yeah,
Mr. Goldberg indicated that upon discovering it, he discussed it with his co-counsel, and there was a decision not to disclose it.
yes.
Is there anything more you need to argue?
I really don't think so. I think it's it's intentional misconduct.
All right. All right, the court is concerned about this situation because I did order the production of these original documents. And I accept the representation that the initial production of what turns out to be a photocopy of the real page 4, that the failure to disclose that or to keep it with the originals was inadvertent. And in examining the two items, both what was originally, let's see, we have to be precise in our terminology here, the original page 4 that was disclosed as and purported to be an original, and then the late discovered original. In examining the two forms, the court finds that they are identical except for a poor Xeroxing of one of them, that there is no information contained. They are essentially blank forms. So as far as the content of the form itself, there's no Brady content here. Therefore, the failure to disclose this is inadvertent, and it's a no harm, no foul. The other issue, however, is the originality of the form itself. There was a discovery issue as to that. The court did order its disclosure. I find that the failure to disclose both to the court and to defense counsel the discovery of the original document, page 4, to have been intentional and should have been done prior to the conclusion of the cross-examination by Mr. Scheck. And the field notes are Defense Exhibit 1107, is that correct?
Yes, sir.
Your Honor, could the court perhaps look in the record to see whether Mr. Scheck said no further questions before we found it? Because I'm told that that may be the case, that he actually formally said that.
I did examine the record yesterday. What he said was, after these two items, I have no further questions. And we were at that time exhibiting the documents to the jury.
Can we double check on that?
Absolutely.
Because
Be my
I'm
guest.
told that-
I know it, Your Honor, I was there. We didn't find this until the cross-examination was concluded, until he stood
Ms.
up
Clark,
before the court.
Ms. Clark,
Your Honor, we can't
fine,
produce
wait,
what we don't
Ms.
have.
Clark. I'll have Mrs. Robertson get the transcript from yesterday. On approach, let me give you the court's transcript from yesterday, see if you can find that location. But I recollect specifically checking it myself. All right, do you want to read it to me?
I'm reading from page 22,781. May I just have one moment, Your Honor?
Certainly.
Sorry. Your Honor, I'm looking at page 22,781.
Yes.
The court is speaking. All right, Deputy Russell, would you return that document to Mr. Scheck? All right, the record should reflect that each of the jurors has had an opportunity, including the alternates, has had the opportunity to review the Defense Exhibit 1107. Mr. Scheck. Mr. Scheck. Yes, Your Honor. I just would mark page 4 of this crime scene checklist 1107B. I have no further questions. Court. All right. And then Your Honor continues, ladies and gentlemen, I'm going to take a 15-minute break at this time, and so on.
Prior to that, go back to the second couple pages before that.
To the what?
If you recall, we had when you were making your request for a break between the cross-examination conclusion and the beginning of your redirect, I asked Mr. Scheck, do you have anything else? And he said something to the effect, I thought I said no further questions. And my recollection is I heard him say, after these two things, I will have no further questions.
Well, you see, the problem is, Your Honor, I don't know if that was recorded because...
No, well, it's in the transcript.
What?
Flip back a couple pages. That's the benefit of having the real-time reporting, because I was anxious to see whether or not Mr. Scheck was really done.
Well, it must have been much earlier if it occurred. See, does Your Honor recall whether this happened?
Well, why don't you hand me the transcript?
Right,
Maybe I can
okay.
find it. It's at page 22,776 at line 21. Mr. Scheck, Your Honor, I would like to do two more things, and then I'm finished questioning this witness. That's the passage that I'm referring to, at 22,776.
May I have the opportunity just to address this information, since we didn't have that when we argued first?
Certainly.
I don't the reference that the court just read happened, I believe, prior to the exhibits being shown the witness? Item number 4?
No, that's
page number 4?
That was
Or what?
after.
But it wasn't after he had concluded examining the witness, because I believe there was still examination on those exhibits, fairly extensive examination, as I recall, between then and the time that he said.
No, there were no further questions put to the witness.
Okay, but I still don't understand the significance of that particular passage in light of the passage where Mr. Scheck did say on the record prior to the break that he had rested. I mean, that is the posture that we were in at that time. He had completed his examination.
Okay.
And that's what we believe to be significant here. Now, if the
All
court...
right. No, I agree with you that that particular passage of the transcript is not particularly elucidating one way or the other. The issue is, once you've discovered it, did you have an obligation to disclose it both to the court and counsel?
Then after they have rested, if the court is saying we had an obligation, and you know, then you have to go back legally to what our obligations are at that point. At that point,
We've already discussed this part of it.
Okay,
yes.
all right. But at that particular moment in time, he's already concluded his entire cross-examination. He's already said that Mr. Fung is conspiring based upon the non-existence of staple holes. So if we can try to back ourselves up to that moment in time, what is going to be done at that point in time? What is it exculpatory to the defendant if we say, Your Honor, we have this piece of evidence? Is that exculpatory
No,
evidence?
counsel, you're arguing all the other issues. I was only interested in the...
But what I'm trying to get at, Your Honor, is if we back up to that precise moment in time, what would have been done from then forward? I mean, let's say we had come up to the court and said, Your Honor, you know, we have this document, and it's this...
Do you agree that's what should have been done? Do we agree on that point?
Well, if I have to agree to that in order to win, but we discussed it with all the... You know, Your Honor, I just don't want to get into a argument over the court with something if Your Honor has already made up your mind on it. We discussed it. We felt that he had rested. We felt that there wasn't anything that could have been done at that point in order for the defense to erase what they had done, or that the court would give them the opportunity. There wasn't anything that they could have learned by examining the documents more carefully. So if you back up to that moment in time, don't we have to try to articulate from that point forward what would have been done had we come up to the court and said, Your Honor, we found this item of evidence. Would the court allowed him to reopen? And then if he reopened, what would have he done?
Well,
What would if he
court
requestioned
has been
him?
known to allow counsel to reopen.
Okay, but then if the defense is asking for a sanction, don't they have to show where the harm is? In order to articulate the harm, don't we have to back ourselves up to that precise moment in time and run forward and try to replay what would have occurred had it been done differently by the prosecution?
Well, don't you think the defense has just sort of been embarrassed that it set up a scenario where they accused Mr. Fung of having destroyed an important document that might document certain important dates and times, and left that impression with the jury, which is totally empty if this is the real page 4?
I don't know whether they're embarrassed or not, because they've come up with so many other things that they've tried to use to shoot down our case that have been very easily disproved and dispatched. But Your Honor, the point that I made is it's a tactical choice. And are we accountable for the tactical choice?
All right.
I'd ask the court to make a finding as to whether or not the defense engaged in a tactical choice here.
Oh, no, obviously they did, but
They did.
counsel, here's the problem. I ordered its production. That's the foundation for all of this discussion. I ordered its production. It wasn't produced. It should have
You know,
been.
Mr. Cochran, you know, is continually talking and making comments to me off the record. Well, he's saying it in a voice loud enough so that it's...
Well, counsel, I'm
audible.
hearing commentary from both sides of the bench.
Okay.
All right, thank you.
Mr. Hodgman is here to address the discovery order that's made by the court concerning the original And the truth of the matter is, that had the defense wanted to get at the truth and get that document, page 4, original, they
Mr.
could have
Hodgman?
told us so. They failed to. Mr. Hodgman is here to address the fact that they never requested that original. And what has happened here is they are paying for their own tactical choice. If they wanted to find out...
Ms. Clark,
whether
are
it
you
existed
addressing
or
this
not in
issue, or is it
defense,
Mr. Goldberg?
Mr. Hodgman is here to address the discovery matter.
Thank you. Mr. Hodgman. You're on.
And good morning, Your Honor. I understand my name has been taken in vain this morning, so I thought I would come down to see if I can be of any help in enlightening the court. And as the court has asked, I will offer to the court what I know about the situation. First of all, in terms of my direct contact with the question document examination, I had asked Mr. Yolkelson of our office to handle that more directly. I was a participant in some of the communications with counsel in terms of setting that up, as well as with Mr. Matheson at SID. And some of what I'm about to relate to the court is
Mr.
based
Hodgman,
upon...
let me just cut through all of that, because I know that you and Mr. Yolkelson were involved in the discovery discussions between the parties, but the issue is, do you acknowledge that the court had ordered the production of the original documents?
Yes, and we made every effort to turn over those documents. In fact, counsel,
Okay.
Mr. Neufeld, had alerted us to the fact that there was apparently, well, actually, my recollection may be a little vague on this. I think we alerted Mr. Neufeld that there was one original that we couldn't locate, and Mr. Matheson had informed me about that.
Do you recall which document that was?
I recall it as being L16/31, which at the time we believed was two sides of the same single page. I think in the interim we've determined that those are in fact two pages.
We agree that that comports with our recollection.
And I see the affirmative nodding of heads from defense counsel, so that appears to be the case. And with that, I know Mr. Matheson undertook to find that particular page, that missing page, which subsequently, and I'm unsure as to the exact point in time, we did. And all of this was in the spirit, Your Honor, and I think Mr. Neufeld, with whom I was communicating primarily on this, and I know Mr. Yolkelson was having additional conversations, was in the spirit of trying to comply fully, openly, forthrightly with the court's order. Until yesterday afternoon, I never knew about this page 4, which Mr. Scheck was utilizing in the course of his cross-examination. As far as the discovery of page 4, it appears that it was discovered as represented. I can't shed any new facts on that, but it appears into the fact that it was not turned over was certainly inadvertent, as the court has pointed out. And as far as the manner of disclosure, if counsel was aware of it, I would think if had they alerted us, we would have made efforts, in fact, gone to great pains to attempt to sort out the situation for the defense, for the court, for purposes of getting at the truth. We have no interest in hiding the truth, Your Honor. And as I'm reminded from Ms. Clark, and I can speak for Mr. Yolkelson on this as well, we were never notified that that particular page, this page 4, was missing.
Well, Counsel, I've already made a finding that the failure to locate the original page 4 up until and including yesterday was inadvertent. And then examining the two documents, there's nothing on it. So there's obviously no Brady content. There couldn't be, because it's just a blank form. The issue being, should it have been disclosed as soon as it was discovered that there was an original, and it was the linchpin of an interesting argument made by the defense, rather than springing it on the witness to the surprise of the defense during the first phase of redirect.
And the only reason I bring the point up, Your Honor, is with regard to the issue raised by Mr. Goldberg, which I believe is a valid issue about tactical choice. Had we been notified, had a phone call been made, we would have made...
But isn't the foundation of everything the court's order to produce?
Yes, and the court did in fact raise the court order. All I'm saying is, had we known that that particular original had not been produced, we would have gone to great pains, great efforts to find it for them so that they could have had it, but we never got that notification.
All right. Thank you, Mr. Hodgman. All right, I find that the failure to immediately disclose to the court and to counsel was a violation of the court's order, and I'm going to instruct the jury as to that. All right, let's have the jurors.
Ronald, please hear what the instruction is going to be before you do it.
I've heard your request, I've heard their request. I don't think preclusion is, I forgot to also add, I don't believe preclusion is an appropriate remedy,
Your Honor,
We would-
be heard as to other issues before the jury comes out.
such as,
Well, we would like an instruction to the jury as to the videotape, that they intentionally did not disclose that videotape to us yesterday, a series of videotapes at the Rockingham location, in identical words to whatever the court is going to now instruct the jury. We think we're entitled to that. We think this is a completely analogous situation. I did not ask for it at the time because, quite frankly, I was thinking no harm, no foul, which is the way I felt this should be resolved. But we would ask for that kind of admonition. Second issue is the phenolphthalein issue.
all right, what is the likelihood we'll get the phenolphthalein today on your redirect?
It's fairly likely.
Yeah, we have some additional points on the we'd like to present on that issue at some point.
Which is why I tried to start at 8:30 this morning. All right. For your information, the court will instruct as follows. In this case, in a pretrial motion, the court ordered the production of the original field notes, Defense Exhibit 1107, for the purpose of examining these items by a question documents examiner. At the end of the defense cross-examination of Mr. Fung, the prosecution discovered in its possession what purports to be the original page 4 of Defense Exhibit 1107. The prosecution should have immediately disclosed this discovery to both the court and the defense counsel. The failure to immediately disclose was a violation of this court's order. And that will be the court's instruction.
I would,
All right, I'm not inviting argument on that, counsel.
well, Your Honor, may I just make a record then?
You've made your record, counsel,
Well-
more than adequately. I've allowed you to argue more than an hour today.
Well,
No, you-
I don't think I took up a lot of that.
No, this
time.
argument has gone way beyond its need. I've allowed both sides adequate record-making. I've made my ruling.
Well, Your Honor,
Mr. Scheck, last time, I've made my ruling. All right,
The proposed instruction is that we submitted to the court.
it's here, it's in front of me. I've read it, I've considered
Make
it.
it part of the record.
Absolutely.
All right.
You filed it, I take it. Yes, all right.
The court refusing to admonish the jury concerning the defense willful refusal and disobedience of the court order to advise us ahead of time about the videotapes.
Counsel, I haven't gotten to the issue yet.
I thought the court...
Let me see counsel at the sidebar, without the report, please. All right, we change court reporters? All right. All right, Ms. Clark, you had a request of the court regarding sanctions.
Yes, Your Honor, I did. The people have made a request of this court that the jury be admonished concerning the defense willful withholding of the videotapes and their production and notice to the prosecution in violation of the court's order. And the court's made this order a number of times, requiring that both sides apprise the other.
I meant as far as timing.
And as far as timing, and my request is that if the court is inclined to give an admonition concerning the prosecution's discovery issue on page 4, that it withhold that admonition until we resolve the admonition concerning sanctions against the defense for their willful refusal to obey the court's order concerning production of the videotapes, and that the admonitions be given at the same time, if any admonition is to be given at all. And so, since the court has indicated that it is inclined to resolve the issue of defense, an admonition to the jury concerning the defense violation of the court's order concerning production of the videotapes until 4:30 Monday.
Slow down.
How you doing, Janet? She hasn't thrown anything yet.
Court
I'm
reporter
doing
is
okay.
going cross-eyed on me.
Who's smoking? I know.
Okay.
They usually throw things at me. That's my first cue. I
No,
would
they
ask that
send
we-
me messages here.
Did she? That we resolve all of those issues at 4:30 on Monday, and the court give all admonitions at the same time. And that's what I'd ask the court to do at this time.
All right. Mr. Cochran?
Excuse me. Let me also remind the court, I'm reminded by Mr. Darden appropriately, that the defense violation of the court's order resulted in a 2.5-hour delay yesterday because they did not advise us.
I was the cause of a lot of that.
What? No, but you know something, they were really the cause of it, Your Honor. That's the truth. You know, it's very gracious of the court to take some responsibility, but it's not the court's responsibility. The defense should have told us about those
All
tapes
right,
and
we're
failed
arguing
to.
the issue at this point.
Yeah.
The only issue is whether or
Okay.
not I should withhold the sanction instruction now. Mr. Cochran? Thank you, counsel.
Thank you very kindly, Your Honor, and I appreciate the opportunity, and I'll be brief, Your Honor. Again, as you so often said, they're comparing apples and oranges, Your Honor. This is a situation, a violation that occurred right with this jury yesterday that needs to be corrected. The court could have very easily and would have probably allowed counsel to reopen to carry this thing. They made an intentional decision out of the mouth of Mr. Goldberg, so I don't want to relabor it and re-argue that. So this needs to be dealt with right now. With regard to that, Your Honor, and the sanctions are Your Honor's business. You've had under submission now for almost 2 weeks additional sanctions regarding the prosecution. We're not asking you to do that, and we have this rule of one lawyer talking per side, which consistently is violated by the other side there. And, you know, we tried not to do that, but I feel constrained at least to point
Not
out.
always successfully.
And certainly, Your Honor, when we address you, I think you can point out that we address you in a respectful manner, not in a hostile manner, standing up when you tell us to be quiet, we sit down and do that. And I think that should work for both sides. And I hope and I pledge to you we're going to do that from our side. But the point is, this is a violation which the prosecution has been caught red-handed in today, Your Honor. Mr. Goldberg, to his credit, stood here and said, all of them, it's not just Mr. Goldberg, all of them sat here and made a conscious decision to violate your court order. That's a different situation.
He
When
didn't name Mr. Darden.
well, he said,
No, he didn't name Mr.
well,
Darden.
he said, excuse me, well, exclude Mr. Darden, he said all the rest of them, including Mr. Harmon, Mr. Clark, all the rest of them sat there,
He
including
didn't
Mr.
cite Ms. Martinez either.
Well, we'll exclude Ms. Martinez and Mr. Darden, but the rest of them made a decision, and we saw them in court discussing it yesterday. The point is, Your Honor, this is something that needs to be dealt with right away and right now. With regard to and we're more than happy to have you look at the videotapes. What you're going to find is they had all of those videotapes, with the exception of one that came here, Your Honor. It was delivered in this courtroom, and we gave it to them immediately. There's no violation. And what happened was, unlike this situation where they made a tactical decision for an advantage and then tried to do this in front of the jury, they saw these videotapes. They went back in your chambers. You gave them the chambers for all that time. If we got a
We're arguing
videotape.
the motion at this point.
Yes, I don't want to argue it, but I think we welcome that. But this is a separate situation, as you so correctly have pointed out in the past, and I'd ask you to proceed. You know, when they're wrong, and we have to deal with that, as we've done in the past. Let's move this on. We have 12 people, we have 19 people now, 18 people back there who've been waiting all this time, 18. And I hope it doesn't get any less. But we have 18 people back there who have a right to proceed, and we have a right to have this corrected today. The wrong was yesterday. They should have corrected it yesterday. They made a decision, and they can't hide behind the fact they want to bring up something on us. We're professionals. We should go forward at this point and deal with it. We welcome any discussion, because you're going to find there was no violation regarding these tapes. They had all the tapes. They should watch them. And then when we got the new tape, he then showed it to them, and you let them have their chambers for that reason. So I'd ask you to proceed with that, Your Honor, and I thank you very kindly.
All right, thank you, counsel.
Your Honor,
All right, I'm sorry.
may I just point out one thing? Just one. The situation is identical. It's a tactical decision that the defense made to brandish a videotape before the jury in a grandstanding fashion in violation of the court's order requiring us to object in front of the jury. No different. It's a tactical decision that they made deliberately with knowledge, repeated knowledge
All
of
right,
the
we're
court's
arguing the
order.
motion again. The
Okay.
issue is, do I do all the sanctions at one time,
That's why.
or do I do them piecemeal?
But that's why I think the sanctions should be resolved all at the same time, because it is the same issue and the same conduct that we're being accused of, and I don't think it's the same. I don't think that we are in violation, but clearly they were, and they did it on purpose.
All right, thank you, counsel.
Can I say one thing? One thing.
You just can't stand letting me have the last word. It's clear.
Your Honor,
This has got to end at some
no,
point.
it is. This is going to end, hopefully, Your Honor. Your Honor, with regard, Your Honor, to the tapes, nothing was brandished before the jury. They had already seen those videotapes, and the court excluded the jury. And we looked at the tapes. They had every reason. They called Van Adder over here. They had people come down. This is a different situation, Your Honor. We acted appropriately, Mr.
No, we're arguing the motion again, Mr.
Yes,
Pepper.
but I mean, they're separate things, Your Honor. You see that? I mean, it's a separate thing. It's apples and oranges, or apples and watermelons. It's different. One thing.
Thank you. All right, we do have other sanctions matters on, is my recollection. The Harmon sanctions motion. Ms. Clark, are you going to file any papers on the videotape?
Yes, ma'am.
All right, file it by Tuesday morning. All right, all further sanctions issues will be taken up Wednesday afternoon, April 19, 4 o'clock. All right, let's have the jury, please. Matters in the half hour before we were scheduled to start at 9 o'clock. As you can see, our half hour turned into a little longer than that, so I apologize to you. That's the bad news. The good news is that, as you know, the staff has been arranging for you periodically different entertainment, and I think you'll be very happy with the entertainment that we'll provide for you this weekend. It'll be something, special. I mean, we've done some special things for you, and I know you appreciate that, and we appreciate your bearing with us, so I'll try to make up to you for it. Just keep that in mind. I apologize to you. I see your smiles. You understand we have these problems, and I thank you deeply for your indulgence in these matters. All right, do we have Mr. Fung available? All right, Mr. Fung, would you resume the witness stand, please? All right, good morning again, Mr. Fung. You were reminded you were still under oath, sir. Mr. Goldberg.
Thank you. Your Honor, I'd like to put People's 182 up on the Elmo, if I may. Could we get a close-up of the upper left-hand corner? Mr. Fung, when you examined this document briefly last night, did you see a variety of paperclip holes in that document?
Staple holes, yes.
Staple holes, sorry. And also what would appear to just be some black artifact little dots.
Yes.
And could we, perhaps using the telestrator, see if we can mark the various paperclip holes that you saw in this document? Maybe you can direct us.
Down.
Mr. Goldberg, is this really necessary for him to look at telestrate all of the staple?
I'd just like to get some of them. Maybe we'll do 3 or 4 if we can. There are a number of them there, and I just want to show the jurors.
Well, we have the document here. We can show it to them. Don't you think it'd be easier for them to look at it?
I'd like to do that too, if I may do both.
All right. But it seemed to me that they're looking at the document. There appear to be.
Okay, down, over to your left, a little bit more, there. Down. It's hard to make out on the screen here.
Okay, can you see them on the larger screen?
Not from this angle. Down from there, and to your right, and down a little bit more. There's one there. It appears to be there. And one more.
Let's see if we can get another one, if you can see one, if the resolution's good enough on your screen, Mr. Fung.
Right next to the one on the bottom, there's one at the 2 o'clock position. Right there.
Okay, and now perhaps we could put the next document. It's 1107B, defense exhibit on the telestrator. And Mr. Fung, if you see the way that this is positioned on the telestrator, do there appear to be little black Xerox dots that corresponded to some of the actual holes that were on the other exhibit, the real page 4?
Approximately, yes.
And is that what you were referring to when you were saying that you did a preliminary evaluation of the document?
That's just one of the characteristics that I looked at, but yes.
What were any of the other characteristics you looked at?
I looked at the folds in the upper left-hand corner of the document and the holes, paper punch holes, at the side of the left-hand margin.
Okay, Your Honor, with the court's permission, I'd like to pass these 2 documents through the jury.
While the documents are being passed to the jury, may we take the opportunity for a brief sidebar?
Yes. All right, thank you, counsel. Proceed.
Sir, in directing your attention back to People's Exhibit 182 for identification, was any part of that exhibit ever filled out?
No.
And the portion that says time leaving crime scene, let me just put that up.
One, please.
The portion that says time leaving crime scene was not filled out.
No, it was not.
May I just have a moment? Your Honor, next I'd like to take a look at the Defense Exhibit 1107 with item number 17, 18, and 19. Your Honor, do the lights need to be dimmed in the courtroom for us to get resolution, better resolution on this? Sir, with respect to this exhibit, can you tell us again how this exhibit came into being?
On the morning of June 14th, Ms. Mazzola wrote down items of evidence which had not been previously written down in our evidence collection checklist.
Okay. And is this an official form of the Los Angeles Police Department, what we're looking at right now?
No.
Is this a document that has, that's two-sided?
No, it's not.
All right. So in the ordinary course of the crime lab's business, when you're documenting items that have come from a crime scene, are you supposed to use this kind of form?
No.
Or this just a blank sheet of paper?
No.
Right. And then at some point, you became aware that Ms. Mazzola had written it on this piece of paper?
Yes.
What did you tell her at that point?
I told her to place this information on an evidence report form that's included with the crime scene checklist.
All right. And could you have simply told Ms. Mazzola, look, this is sort of a Mickey Mouse thing here?
Sustain. Phrase question.
Could you have told Ms. Mazzola simply to throw this away?
Sustain. Rephrase the question.
Under the policies of the crime lab, was there any obligation for you to save this document?
As it was written there, no.
Was there any custom within the crime lab that you're aware of that required you to save this document?
No.
Would there have been any rule or procedure that would have been violated had you simply told Ms. Mazzola, throw it out and write a new one on an official form?
No.
So did you make a decision to preserve this document
Yes.
and maintain this document?
Yes.
And did you know full well that when you made that decision, copies of this document and eventually the original would be available to the defense in discovery?
Sustain. Rephrase the question.
Sir, are you familiar with the procedures of discovery?
Some of them, yes.
Okay. And are you aware that the defense is entitled to copies of documents,
Yes.
including this one?
Yes.
objection?
I have an objection to that question with respect to matters that have been discussed.
Overruled. Proceed.
So, Mr. Fung, if I understand your testimony, is the evidence that the defense has here that they claim shows some sort of conspiracy on your part, does it exist simply because you maintained it and preserved it?
Sustained. Phrase the question.
Thank you. You maintained this
Yes, I did.
and preserved it.
Yes, I did.
Your Honor, I'd like to have a sidebar on this issue.
Overruled. You can cross-examine on that, counsel.
Your Honor, there's an issue here, I think that,
With the court reporter, please. All right, are we done with this exhibit, Mr. Goldberg?
Yes, Your Honor. And now, I just want to approach this, if I may, with this document, and just ask him one more question.
One more.
Sir, with respect to this item number 1107, what is on the front of the form?
The front is the field notes
Okay.
portion.
I'd like to see the other document that's part of 1107. It's the page that has items 17, 18, and 19 written in it.
One, please. One, please.
Sir, and what is this form again?
This is an evidence collection report.
And is this the form that Andrea Mazzola created after you told her that you didn't want the items on that blank sheet of paper that's on the reverse of the field notes?
Yes.
Okay. And when you first saw it, what were the order of the items?
I'm going to refer to my copy. The order of items was that 17 was in the top box where 18 is. 18 was next to it or below it, and 19 followed it.
And how was that problem dealt with? What did you do about that?
I erased 17 and 18 and changed the numbers
Oh, I'm
around.
sorry. I think monitored up here for jurors 1 and 2 is, do we have it on? Mr. Fairtlow? Where's Miss Fitzpatrick? Is it on? Fine, thank you.
Now,
Mr.
Mr. Fung, if you write out a report in the crime lab and you make a mistake on that report, or there's something on it that you want to change, is there any rule that says that you can't simply, if you're in the process of creating the document, throw it away and start over again?
There's no rule to that, no.
Did you ask Andrea Mazzola to do that with respect to this document?
No.
So did you decide to maintain this document?
Yes.
As a criminalist 3, could have you said, would have it been within your power to have said to Andrea Mazzola,
Finish the question, but it sounds like it's leading.
okay, do you have the authority as a criminalist 3 to tell a criminalist 1, clean up this document, write out a new one?
Yes, I do.
Did you do that?
No.
Now, you said that you had no recollection of talking to, thank you. No recollection of talking to criminalist Mazzola specifically about the circumstances under which you got the blood vial, is that correct?
That's correct.
And why was it that you, well, did you have a recollection of talking to her about things like the circumstances of collecting
Overruled.
the blood on the trail at Bundy?
No.
Okay. Well, do you believe that, do you have a recollection of talking to Ms. Mazzola about collecting items on the trail at Bundy?
Yes.
Okay, what about at Rockingham?
Yes.
What about the glove and the cap at Bundy?
Just briefly.
Okay. And why did you talk about those items but not the vial? Or why is it that you remember?
Objection is to time when these conversations took place. These questions are vague.
Sustained.
You said that you had a conversation that was at some point after the Griffin hearing with Ms. Mazzola.
Yes.
That's vague to the jury, too.
Well, but they, oh yeah, that's true. Yeah, I think it was. Perhaps we could later on have that, the court take judicial notice of that. Sir, was there a hearing in which you were questioned by the defense about various aspects of things you did on the 13th in collecting evidence with Ms. Mazzola?
Yes.
All right. And at some point after that hearing, did you have a conversation where you tried to determine who specifically picked up certain items?
Yes.
And you have a recollection of talking to her in that conversation about the trail at Bundy and the trail at Rockingham,
Yes.
and probably the cap and the glove?
Yes.
And why doesn't the issue of the blood vial stand out in your mind?
Objection. I don't believe he's competent to talk about why he forgot to tell her something.
Overruled.
Could you repeat the question, please?
Did you consider the issue of the blood vial to be particularly important in terms of who collected it?
No.
And you were asked certain questions on cross-examination about whether or not you were anticipating the kind of accusations about the blood vial. Do you recall those questions that were made during cross-examination?
Yes.
Mr. Fung, were you anticipating those kinds of accusations?
No, I was not.
Were you surprised?
A little bit. Yes.
Okay. And in your mind, was the issue of precisely how the blood vial got from Mr. Van Adder, Detective Van Adder, out to the crime scene truck all that important to you?
Overruled.
No, it was not.
Did you know that it got out there in some way?
Yes.
Did you try to make a mental note in your mind as to specifically what was happening at the time that you got the blood vial?
Leading.
Overruled.
My only concern was to note who I got the item of evidence from and the time and the date that I got the evidence.
Did you do that?
Yes.
When you received the analyzed evidence envelope, or the evidence envelope, rather, containing the blood, did you make it a point to call out to people, "Hey, everyone, I'm getting the vial. Can everyone gather around so I can have some witnesses?"
Sustained.
Argumentative.
Sustained.
Oh, I'm sorry, Your Honor. When you got the blood vial, did you make it a point to try to gather people around you?
No.
Did you make it a point to try to get people to notice what was happening so you'd have witnesses?
Sustained. Rephrase the question.
Did you make any effort to make sure that there were a lot of people around when it happened?
Objection. Leading again.
Overruled.
No, I did not.
Why not?
That's not part of, I would think it would be unprofessional for me to make a big deal out of collecting a single piece of evidence.
Did you try to do that with any other piece of evidence, get people to witness you collecting it on the 13th?
No.
Overruled. Overruled.
Now, when you got on the witness stand in this case, did you recall all of the facts and circumstances as to specifically how the item was carried out to the crime scene truck?
No.
And when you were suggesting to Mr. Schecht various ways that it could have gotten out to the crime scene truck,
Objection. Misstates the evidence, not suggestions, testimony.
Sustain, rephrase the question.
okay, maybe I'll read from the transcript, Your Honor. I'd like to read first from page
'em. He's about to give us a page.
Yes, it's page 22,457.
And I take it that's from the 12th?
It's from the 12th, yes, Your Honor. Do you recall giving the following answers?
Excuse me, just a second. Counsel, do you have that?
Oh, it's starting on line 1 all the way down to line 18. Afterward. Question. And you just refreshed your recollection by looking at your notes? Answer. Yes, I did. Question. And the notes reflect that those items were picked up at 5 o'clock? Answer. Yes. Question. And since you are telling us that you received this blood vial at 5:20, you have concluded that this was after those 2 items were collected? Answer. Yes. Now, but do you have, as you sit here today, an independent recollection of the order in which you received the items, other than looking at your notes? Answer, no. Do you recall that line of questioning?
Yes, I do.
And did you have an independent recollection of the time that you obtained that vial, other than what was reflected in your notes?
No.
Or the order in which it was collected with respect to other items?
I didn't have an independent recollection, and I still don't, no.
And is that because, as far as you were concerned, it wasn't that significant?
Sustained.
Your Honor, I'd like to read another quote from page 22,444, and it starts on line 23. Do you recall giving the following answers to the following questions, sir? Question, and after you received the envelope from Detective Van Adder in the foyer, did you then walk out the door to the crime scene truck? Answer, I don't know if I did that immediately or if I had other things there I had to do prior to that. Question, did you put this envelope in a brown paper bag? Answer, I don't recall if I did or not. Question, did you put it inside your black kit? No, I don't think I did that. Question, did you at some point walk out of the foyer to the crime scene truck holding the gray envelope? Answer, I don't believe so. Question, well, what did you do with it? How did you get it to the crime scene truck? Answer, it may have been in a paper bag, but I don't recall if I actually did put it in there, or it may have been put in a posse box. Question, Is it possible that you just walked out the door with the envelope in your hand? Answer. It's possible, but I don't think that that's likely. Do you remember giving those questions to that answer, those answers to those questions?
Yes.
And at that point in time, did you have an independent recollection? Meaning, from your own memory of what happened on the 13th, as to exactly what receptacle, if any, you put the blood vial envelope in?
No, I did not.
So where did you come up with the various possibilities that you were speculating about?
Objection is to speculations. There's
Sustain.
testimony after
Sustain.
lunch, after these questions.
Raise the question.
Mr. Fung, where did you come up with those various different possibilities?
Those were packaging items that are in the crime scene, available in the crime scene kit, and I named those types of packaging or packages off.
Okay. But did you have any memory at that time of putting it in a brown paper bag as opposed to the posse box, as opposed to just handling it without putting it in anything?
No.
Okay. Your Honor, at this time, I'd like to mark as people's next in order 2 photographs of what appear to depict the packaging of item 17.
183 and 184.
Or does the court want me to mark them 183A and 183B?
How about 183 and 184?
Okay. I just want to approach the witness first before I show it, put it on the Elmo, if I may.
You may.
Sir, showing you what's been marked as People's 183 and 184 for identification. Do you recognize that?
Yes, I do.
What does that depict?
This depicts the front and back of the envelope containing item number 17.
I don't know whether the resolution is going to be good enough, Mr. Fung, but you said that you documented somewhere that you received this from Mr. Van Adder, the date and the time.
Yes.
Can you point that out for us?
On the photograph to the right, which is the picture of the rear or the back portion of the envelope, there is writing, well, it's between the yellow seal and the red seal in the middle, and it says, received from Detective Van Adder, his serial number 14877 on 6/13/94 at 17:20, and it has my signature there.
And when you wrote that on there, do you know where you got the time from?
I looked at my watch.
Your Honor, I have another item from People's 160. Your Honor, this time I have an item that's comes from People's 163, and it's 163I for identification.
All right,
If I may approach the
163I. You want to show that to Mr. Scheck first?
Sir, show me People's 163I for identification. Can you tell us what that is?
This is a LAPD sealed evidence sticker.
Okay, so is that the type of sticker that you used when you eventually sealed this before it was placed into the evidence control unit?
Sustained. It
Did
also
you-
assumes facts not in evidence at this point.
Did you use this type of sticker on this item?
Objection sustained and assumes facts not in evidence.
Overruled.
Yes.
Right. And can you just point it out for us on the Elmo where that sticker would be? Which one, the yellow or?
The red sticker in the, it's about 2/3 across the screen.
And was this item eventually brought into the evidence control unit?
Yes, it was.
On what date?
That was booked into ECU, which is the evidence control unit, on June 16th.
Okay. Could we circle using the telestrator, perhaps the time, the 7:22? 17:22. And the date, Mr. Fairtlow. And does that date go under the seals?
The seal appears to cover that writing, yes.
Okay.
The item that you're referring to, the date and time.
Yes, he did.
Your Honor, at this time, I'd like to play another videotape that we have of the events on the 13th at Rockingham. I don't know whether we've discussed that.
I don't believe we had. Let me see council side. All right, thank you, counsel. Proceed.
Your Honor, I'd like to move on then to another video. It's Defense 1104. And first, there's a clip of Ms. Mazzola leaving the location.
All right, Mr. Fairlow, do you have that available?
I believe it's 1102.
Three, please. No audio.
Can we replay that portion for a second? Back it up just a little bit. Stop. Can you just back it up a couple frames? Okay, stop. No, you almost got it. Okay, there. Mr. Fung, looking at that bag, does it appear to you that there is some rectangular item
Objection,
in
the
it?
evidence speaks for itself.
Leading question, counsel.
Mr. Fung,
Also, objection, competency with respect to this speaks for itself.
Mr. Fung, directing your attention to the bottom part of the bag that Andrea Mazzola is handling. Does that appear to be containing something?
An object does appear to be at the bottom of that bag, yes.
Could we have that item printed, Your Honor?
Yes, please. And before we move on from that frame, let's see what comes out. What's the print time on this, Mr. Fairlow?
From the original frame reference where I queued it up with 006, so I would need to rewind it from the beginning and play forward in order to set that frame.
No, but I mean, how long is it going to take you to print this copy?
It's set now, I can move on.
No, I just want to make sure that we have that. I want to see the quality of the print.
So it'll take about 2 minutes, Your Honor.
All right, do you need to move this?
From this location? The court's saying that we'll have to delay if we do that.
No, I mean, because of the jumping nature of this particular still, I just want to make sure that the quality of our print is precise, that's all.
Okay.
Since there's a lot of noise at the top of the picture.
Make one more pass through and that should print.
show that to Mr. Goldberg, please? Does that capture what you need?
Excuse me, Your Honor? Yes, that seems to be pretty good.
All right, proceed.
I'd like to mark this as people's next in order. It would be
185.
185.
People's 185.
Sir, may I approach the witness again?
You may.
Sir, I'd like to show you what's previously been marked as 163H for identification. Can you tell us what that is again?
163H is a series of 3 envelopes, which are analyzed evidence envelopes.
And is one of those the same type of envelope as was used to contain the vial of blood that you received in the envelope from Detective Van Adder?
Yes,
Which one is that?
that would be the gray envelope, which is right here.
And is the item that appears to be in the bag in the photograph that we just saw consistent with that in size?
Sustained. Sustained.
Your Honor, perhaps we could ask that that be passed around just so the jury can get a sense of what it looks like a little better.
All right. Also, you might want to measure it so there's a precise measurement on the record.
I have no objection to doing whatever they want to do with this, but I would request that we bring the real thing in.
That what?
Yeah, for this purpose, for the jury to appreciate the size of the envelope, let's proceed, but we will bring the original in at some point.
Okay.
All right. And we have Mr. Fung just give us the measurements for the record.
Lengthwise, from top to bottom, the measurement is approximately 10.5 inches. And width-wise, it's approximately 7.5 inches.
And Mr. Goldberg, may I see 185, please?
I didn't write a 185 on it, if I might do that on the reverse.
Right.
May I approach?
Please. Thank you.
Perhaps while we're waiting, I could also mark the print of People's 184 from the telestrator as 184A.
All right, you want to show that to Mr. Scheck?
Yes.
All right, Mr. Goldberg, would you approach? Thank you, sir.
Permission, could we pass
All right.
Could we-
795 just hadn't handed the last item to the bailiff.
Could we also pass People's 185 around?
Which is,
Well, there's the court's copy, and then there's a People's
It's the
copy.
same-
That's
it's the
our
same.
copy.
can I just look at it for a second?
Sure. Actually, why don't we pass around 185 and 163H at the same time?
So perhaps we could have the front of People's 184 put up one more time, just so I can get a print of that as well.
All right.
One, please.
Now, Mr. Goldberg, you had wanted to pass?
Yes, they still have 163.
All right. All right, if you hand that to juror number 1. Well, I'd prefer to have the jurors concentrate on what they're looking at. Goldberg?
Now, Mr. Fung, when you saw the scene that we just played a few moments ago, that's depicted in the photograph 185, when you saw that for the first time, did that jog your recollection about anything?
Leading and misleading.
Overruled. On the misleading part, it is leading. Rephrase the question.
When did you first see that item of tape?
Your Honor, I think that the problem here is
Vague.
Is he talking about the
Question is
photograph or
vague.
the video?
I don't.
Sir,
right.
Mr. Fung, I'm talking about the
Rephrase the question.
videotape
Yesterday.
that you've seen, okay? That's a still photograph of which is depicted in People's 185. When you saw that, did it jog your recollection about anything?
Yes.
What was that?
It occurred to me that the envelope containing the vial of blood could very possibly have been in that bag.
And when did you first remember the bag at all, the plastic bag?
When I saw the video. No. Early that morning, I was going through it in my mind, and it occurred to me then. I saw the video the day before, a small portion of the video.
Where was
And
that?
Here in court on the monitor.
He's kind of gesturing to the monitor by himself.
Yes.
Okay. And that was the first time that you remembered this plastic bag?
Yes.
Now,
Misleading.
Overruled. Answer will stand.
Now, did you, from a forensic science standpoint, sir, is it significant to you whether the bag was brought out in a posse box or a plastic bag or paper bag, or specifically how you carried it out?
Overruled.
No, it's not.
Is it significant to you from a forensic science standpoint that the vial is closed and that it is, in fact, in an evidence envelope?
Objection. Vague as to the word significance.
Overruled.
Yes.
And this was 10 months ago that these events occurred when you received the vial? About 10 months ago?
Just about, yes.
Is your recollection perfect as to all of the things that occurred surrounding the receipt of that vial?
No.
Okay. Your Honor, next I'd like to see the videotape that's been marked as Defense 1103 and the portion that shows Detective Van Adder arriving at the location.
Read, please. No, audio. Excuse me, Your Honor.
Yes, let's
What
approach
is he
with
showing?
the, hold on, with the court reporter. Mr. Goldberg.
Now, Mr. Fung, when you were in the crime scene processing truck, did you ever say to Andrea Mazzola, Miss Mazzola, I want you to know I have the defendant's vial so you can witness this?
Sustained.
When you were in the crime scene processing truck, did you ever say anything to Miss Mazzola to make a point to her to see that you had the vial, or that the vial was in your possession, your
Sustained.
custody?
Sustained.
Did you ever say anything, make a point to say anything about the vial?
No.
Did you have any reason to do so?
Overruled.
No.
Okay. At this time, I'd like to take another look at the document that's marked 1107. This is the back of one of the pages entitled Field Notes. It has 17, 18, and 19 in it. Maybe we can have a little bit of a close-up version of the 17 and 18, between 17 and 18. Sir, did you have an opportunity to take a closer look at this document and also Xerox copies of this document, particularly the item that appears to have been erased between 17 and 18?
Yes.
And is that in fact your handwriting
Yes.
and your date?
Yes.
Did you initial it in some fashion, or did you sign your name? Or
I put my initials towards the right portion of that circle, if you can see it.
and the date that you put on there was July the 5th?
Yes.
Was there anything of significance that was happening in this case immediately following that date?
One of the hearings was occurring very soon after that date. I forget which one it was.
Did you testify on July the 6th and 7th?
Yes.
And when you testify in court, sir, is it your practice to review documents in preparation for testimony?
Yes.
Now, in looking at this document, have you reconstructed the events that occurred on the 5th that caused the 7-5 writing in your initials to be placed on that document?
Somewhat, yes.
What's that?
I was going through the crime scene checklist and saw that the items were switched, or not switched, were still listed with the tennis shoes as being 17 and the blood as 18, and I wanted to put a note there for myself if I came across them that I had switched the numbers. And after I had wrote it down, I erased it because I wasn't sure if I should alter the document as I was going to court.
So you weren't sure whether, at this point, you should make another entry on the document?
That's correct.
Now, is this something that you have a sharp recollection of, or is this something that you've basically reconstructed after the fact?
This is something I reconstructed.
And is that based upon the date of 7-5 and in relationship to your preliminary hearing testimony?
Yes.
Now, sir, you didn't seem to do a very good job erasing this item, did you?
That's correct.
I mean, do you have erasers available to you at the Scientific Investigations Division?
Yes.
Is there a shortage of erasers?
No.
Is there any reason why you couldn't have done a better job erasing it if you'd wanted to?
No.
And, sir, if you were trying to alter a document with some sort of
Your Honor, leading.
evil intent, do you think it would be a good idea to date
That is.
and put your initials on it?
Sustain. Leading.
Well, let me ask you this, Mr. Fun. If you wanted to alter a document with some sort of intent to mislead, would you leave your initials and the date on it?
Objection, Your Honor, is this a
Sustained.
hypothetical question of an expert?
Sustained. That's sustained objection.
When you did this, did you have any intent to mislead anyone
No.
or to hide anything from anyone?
No.
All right. Now, did you know Detective Lang or Detective Van Adder prior to this, prior to the events on the 13th?
I had spoken to them on the phone, taking requests from them over the years. and I had worked personally with them on 2 to 3 other cases.
Were you social friends at all?
No.
And what about Detective Furman? Did you know him at all?
I have never met the Detective Furman before June 13th.
What about Detective Phillips? Did you know him?
No.
Your Honor, at this time I was going to move to another topic. I don't know whether the court wanted to proceed. I see we do have some time. Okay. Mr. Fung, I wanted to ask you some questions about your grand jury testimony. But before doing that, I want to ask you first, as a forensic scientist, as a criminalist, when someone asks you the question, did you collect a particular item of evidence, what does that term entail, collect?
To me, collect entails the searching for the item, the identification of an item as evidence, the documentation of that evidence through notes, measuring it, and photo documentation, and describing what the item is. That's all done before the actual collection or picking up of the evidence.
Now, of those various steps that go before the actual physical picking up of numbering and photo documenting and so on, which of those steps is most important?
They're all equally important.
Are they equally important to the step of actually physically picking up?
They're important in the to maintain the integrity of the evidence.
Now, sir, when you were at the Rockingham location in the morning of the 13th, using the term collect in the way that you just did, were you involved in the collection process of all of the evidence that morning?
Yes.
And how so?
I identified the items that we were going to collect that day or that morning. I directed the photographer as to which photographs to shoot. I assisted in helping to measure each and every one of those stains. And for some of the items, I actually did some of the swatching.
What about with respect to the items at Bundy that were collected on the 13th? Did you participate in the collection process as you just described it on all of those items?
Yes.
And how was that?
I identified which items we were going to collect. I helped with the measurement of the items that we were going to collect. And I actually did some of the swatching and collected some of the stains myself.
All right. So had you filled out the crime scene checklist portion that lists the people who do the collection where it says by in the crime scene checklist? Do you know what I'm referring to?
In what time frame?
Well, if you had filled it out on the 13th,
Yes.
as to, let's say, stain number 6, just to pick one, what would have you filled it out as?
Any hypothetical, maybe, I think that calls for speculation and it's vague. The witness should testify to what he did or he didn't do.
Overruled.
We were working as a team that day, and if I was to fill it out, I would have filled out that we meaning Ms. Mazzola and myself, both did it.
Okay, but
Overruled.
later on, didn't you go through a copy of those checklists with Ms. Mazzola and kind of check off either both or Andrea Mazzola or yourself next to various items?
Yes.
All right. And when you were doing that, what was your intent in doing that?
It had been a issue in the, I believe it was the Griffin hearing. It was brought up by the defense.
All right. Ask another question.
So it was after this hearing that we referred to as the Griffin hearing that you did this, when you were having the conversations with Ms. Mazzola trying to figure out who did what?
Yes.
And what were you trying to figure out specifically in terms of collection during those conversations?
Specifically, we were trying to remember who did the actual recovery phase or picking up of the evidence.
You mean the physical phase of actually physically picking up the evidence?
Yes.
And that's what you were trying to do?
Yes.
Did that become an issue, in your view, at this hearing that you testified to that we referred to as the Griffin hearing?
Your Honor, move to strike, and I'd ask for curative instruction on the
Overruled. But it is, as to that request, sustained as to the nature of the question.
As to what?
The nature of the question. Rephrase the question.
Okay. There was this hearing that you testified at prior to doing this process with Ms. Mazzola, is that correct?
Yes.
And at that hearing, in your view, did the issue of who physically did what come up?
Yes.
And was that the first time, in your view, that anyone spent a lot of time trying to figure out who physically did what at the crime scene?
Vague. Sustained.
Prior to that, had any member of the prosecution interviewed you with respect to who physically did what at the crime scene?
No.
Had any member of the defense asked you any questions extensively about who did what at the crime scene?
To Your Honor.
Sustained.
And-
Vague.
Okay. Well, in your view,
Your Honor, and it's misleading.
It's vague. I sustain the objection. I'm asking him to rephrase it.
I have a legal objection at some point. Why don't we just...
Phrase the question.
well, prior to that time, sir, had you testified in a in a preliminary, in a grand jury hearing?
Yes.
Okay. All right, well, we'll get to that later. And then, had you also testified in a preliminary hearing?
I don't recall the exact order.
Okay. Now, who was in charge of the crime scene in terms of the work that the criminalists were performing between you and Ms. Mazzola at the Rockingham location in the morning?
I was.
And who was making the decisions there in terms of the discretionary type decisions that are made by a criminalist?
I made the decisions.
Did you feel that you were responsible for all of the decisions that were made as to the collection process at that scene?
Yes.
And with respect to the Bundy scene, who was in charge of that scene?
In terms of the evidence collection, I was.
Did you feel that you were responsible for the collection process at that scene?
Yes.
And what about the return trip to Rockingham on the 13th? Who was in charge of that?
I was.
Did you feel responsible for the collection process there?
Yes.
If you were to divide the workup of a criminalist into the mental component of deciding what to collect, what not to collect, and the discretionary type decisions, and then a physical component of actually collecting, which component were you involved in, do you believe, primarily?
Objection. Overruled.
Primarily, I was involved with the mental aspect of the crime scene investigation.
And what about Andrea Mazzola?
She was the physical portion.
Okay. And when you testified at the grand jury as to who was collecting what, Was this your state of mind with respect to the division of authority there?
Sustained. Raise a question.
What was your state of mind with respect to who was responsible for all the collection when you testified at the grand jury?
At the grand jury hearing, I was in charge of the evidence collection, and I was the supervisor, and I made the decisions.
And under the state of mind, when you testified at the grand jury, who collected the evidence in the sense that you have defined it here today?
Objection.
Overruled.
Calling for,
Overruled.
It was me.
Okay, Your Honor, I'd like to continue with this perhaps later, but maybe this would be a good time to break.
All right. After. All right, ladies and gentlemen, we're going to take our recess for the morning session. Please remember all my admonitions to you. Do not discuss the case amongst yourselves. Don't form any opinions about the case. Do not allow anybody to communicate with you with regard to the case. Do not conduct any deliberations until the matter has been submitted to you. As far as the jury is concerned, we'll stand in recess until 9 a.m. Monday. Thank you. All right.